Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the assessments in lieu of survey conducted on the Assessee. The issue before the Jaipur ITAT A bench in the present case was that whether the revenue has a right to tax the income of the assessee under section 68 or 69 family just because there is a survey on the assessee. And the second issue was that if the case of the assessee does not fall into the conditions of instruction number 4 of 2018, that is 20th August 2018. So in that case, whether the case of the assessee can be selected for manual scrutiny due to a survey. Both the issues have been taken up by the tribunal in the case of Nikhaar Fashions versus Assistant Commissioner of Income Tax, and this case is reported in 131 ITR Tribunal at page number 1, and the date of the judgment is 21st November 2024. In the present case, the assessee is dealing in designer sarees. There was a survey on the assessee and the assessee has disclosed some income. From the facts of the case, it was very clear that when the survey was made on the assessee, then no books of accounts or documents have been impounded by the revenue. And the second fact was that the assessee's return of income was not less than the return income of the previous year, and the assessee has not retracted from the disclosures made during the survey. If we go by the instruction number 4 of 2018 dated 20th August 2018, then there are two conditions for picking up the case of the assessee under manual scrutiny due to a survey. Those conditions says that if the books of the assessee has been impounded during a survey, which can be done only by recording the reasons, or if the returned income of the assessee is less than the previous year and the assessee has not retracted from his disclosure, then his case can be selected for manual scrutiny due to a survey. The assessee addition was made under section 69B, that is amount of investment etc. not fully disclosed in books of accounts. The CIT appeal has not given relief to the assessee, so the matter was before the tribunal, and the assessee pleaded that since no books of accounts have been impounded and the assessee's return of income is not less than the previous year, so the revenue do not have the right to pick up the case of the assessee under manual scrutiny, and hence the whole assessment proceedings are bad in law. The tribunal was with the assessee with this contention and deleted the assessment proceedings on this ground itself. Further, the tribunal said that the revenue do not have a right to change the head of income because of the survey proceedings. The tribunal said that the heads of the income are exclusive. If some income is to be included into the business income, then it cannot be taken into the section 69B income. The tribunal said that the deeming provision should not be applied just because there is a survey on the assessee, and the tribunal was of the considered view that the statement of the assessee should be read as a whole and not in a piecemeal method. The tribunal also reminded about the circular number 7D LXIII of 1967 dated 3rd May 1967, and according to that circular, the survey can be made only at the business or the professional premises of the assessee. That circular prohibits to make a survey on a third party in a survey of the assessee, meaning thereby that if some survey is on one assessee, then because of that survey, the officials cannot visit the business or business premises of the other assessee. And according to that circular, the purpose of survey is to check and balance on the business or profession affairs of the assessee, and this circular gives a clear hint that the revenue do not have a power to record the statement of the assessee in a survey, and if any undisclosed income is found during the survey, that is to be taxed under the head business income and not under section 69B. Friends, this case is very important because it has been seen that whenever there are surveys and any stock is found or some cash is found, and when the revenue has no evidence to prove that this stock is because of some undisclosed investments which is not explained by the assessee, then this case is very helpful to justify the deletion of the additions under section 68 or 69 family. At the end of this video, once again I am repeating the name of the case. The name of the case is Nikhaar Fashions versus Assistant Commissioner of Income Tax, and this case is reported in 131 ITR Tribunal at page number 1, and the date of the judgment is 21st November 2024. Thank you, friends.